room, but under the circumstances, I know people are interested and we're going to look at it. I'm Judge Reisner. There are a couple of fairly important ground rules, one of which is everybody has to be silent. And please silence your cell phones. You can do that now, we'll hear the bings, but silence your cell phones. All right. You'll see that there are only two of us here, and the reason is that unfortunately, Judge Carroll broke his ankle and can't physically be here. But we knew this was important to everybody. We didn't want to put the argument off. All right, good morning, Judge Carroll. I was just explaining to the people in the courtroom that because you broke your ankle and can't physically be here, we have arranged through technology for you to appear here by speakerphone so that we can continue and have the arguments today instead of having to adjourn them. And I've explained to everybody, in part so that the speakerphone arrangement will work, that it's very important that we have silence in the courtroom and that everybody silence their speakerphones.
I appreciate that. I'm sorry I couldn't be with you physically today.
All right, but you're here. So and that's the most important part. We are actually going to hear the Berg case first. I think the Lucia was listed first, but since the Berg case involves more general issues and the DeLucia case involves somewhat more specific and narrow issues, we thought it might make more sense to hear Berg first. As probably the lawyers all know, we frequently interrupt lawyers with questions. We don't do that to be rude. We do it because we want to help the lawyers to focus on what we see as the important or difficult issues. You shouldn't assume that we have reached any conclusions about the case from the questions we tend to ask questions of both sides, and again, it's because we want to make sure that all of the issues are explored. And for the benefit of everybody, for this argument and every other argument, unlike the trial court, you don't have to argue every issue that's in your brief for fear that they'll be waived if you don't argue them. As long as an issue is briefed, it is preserved. The purpose of oral argument isn't to give us a laundry list of what's in the brief. It's really to focus on the most critical issues. So with that, we will hear the Berg case first, and I will ask counsel to give us their appearances, beginning with counsel for appellant.
Your Honor, Daniel Grossman for the plaintiff appellants in the Berg case, except for Mr. Aslan, who is present.
All right.
Charles Aslan, representing the first.
All right.
Ira W. Mintz of the law firm Weissman and Mintz, arguing on behalf of the interveners.
And
Kenneth Nowak from Casella Nowak, Kleinbaum, and Friedman, also on behalf of the interveners.
all right, let's go to the
We were both going to argue.
as long as you don't overlap. That's fine. All right.
Good morning, Your Honors. Robert Logie, Assistant Attorney General on behalf of respondents. Joining me at the table is Deputy Attorney General Diane.
Okay, and you're going to be arguing?
Yes, ma'am.
All right.
Your Honor, we have, on behalf of the interveners, David Fox, we are going to supplement the oral argument after the other returns. We have certain of the interveners.
Okay. Once again, as long as we don't hear repetition, that's fine. Okay, Mr. Grossman, you may proceed.
Thank you, Your Honor. May it please the court, at the outset, with the court's permission, I'd like to reserve a few minutes, perhaps 5, for rebuttal if necessary.
All right, we'll see how it goes. Go
Thank
ahead.
you. Your Honor, my clients are 25 retired public employees who, at time of retirement, most were entitled to receive COLAs. Most of them, I think, either 19 or 20, were receiving COLAs. The rest had vested. By now, I think virtually all of them are not receiving COLAs. In Chapter 78 of the the laws of 2010, the legislature altered the formula by which colors were being made available, so to effectively eliminate them, dooming public employees to whatever they were receiving at the time the law went into effect. They were suspended, but for all practical purposes, they've been eliminated. The trial court acknowledged this court's treatment of pensions in general as contract, looked to the constitutional arguments, and that was his holding. He held on specifically on the debt limitation and appropriation clause. He, in fact, said that as far as he was concerned, we seem to have better the argument on the non-federal rights, on the inclusion of the COLAs and all the contract issues. So his decision was that the COLA was a violation of the two constitutional provisions. We submit and we brief the idea that that was a fundamental error. Both the Supreme Court and this court observed as a matter in passing, personally, that COLAs are uniformly held to be part of pensions. So in 1997, when the referred to pensioners' rights as non-fulfillable and talked about pension benefits programs, it had to have included the COLA because it excluded medical benefits. As far as the, I'm sorry, the error was an understanding, the court's error was an understanding of the nature of pensions. Pensions are nothing more than deferred compensation. They're earned, including COLAs, they're earned and should be paid for in the year in which they are earned. They're not a future obligation in terms of, or rather, not a creation of a future debt. They're a present obligation to be paid in the future. Pensions, and with them the right to COLA, should be paid into a fund with other contributors' deposits, and the aggregate contributions should earn a better return than a single payers. Both sides benefit because the employer can pay less in deferred compensation than he might have to in present compensation because of the historical returns of the funds. The employee benefits because he or she will probably get a better return than he would if he were making a contribution to a sub-IRA that might be underperforming. So otherwise stated, the contribution should be due in the year it's earned. The constitutional provisions about future binding or binding future legislatures should have nothing to do with the present right to a pension. And the pension, inclusive of that, is a COLA. Otherwise, the state could never enter into any multi-year contracts of any sort. We've learned over the last 10 years or so the funds been violated, and that the other two branches of government have used that is other than the judiciary, have used the pension funds as piggy banks to go in funding sprees without any consequences. That doesn't change the legal landscape. They were never intended, pensions and including that COLAs.
Excuse me, we really need to keep the door closed, let's get a little louder here. Okay, go ahead.
They were never intended to be dependent upon the largesse of the legislature and session at the time they were to be paid. They were to be funded on an ongoing basis. So, surely in the current environment, there are hundreds of contract cases within the system where the states fail to reserve against collection, and that's what we're really talking about. Talking about paying presently contracted debts, which may be payment for which has not been funded.
Okay, let's assume for the sake of argument that it's a contract. Under constitutional law, that doesn't necessarily mean that you win, does it? It means that there then has to be a hearing or a determination as to whether the state meets the criteria under which it can, under certain circumstances, impair a contract.
Well, in this case, the underlying right was determined in 1997 non-forfeitable.
Okay,
So,
non-forfeitable means contract, but my question is, under constitutional law, there are certain circumstances in which a state can impair a contract, are there not?
there are certain circumstances under which a state can impair a contract, but the threshold issues have to be met.
Right, and that's the issue that the trial judge didn't address. He
Didn't-
didn't get there.
He didn't get there, but we submit we really don't have to for a number of reasons. Because if there's going to be any kind of hearing at a trial court on that issue, the first hurdle that the opponent has to overcome is what I just alluded to. The 1997 rule for non-forfeitability. So,
But
if-
isn't this circular? I mean, you're saying, I'm asking you to assume hypothetically,
Okay.
that we agree with you.
Okay.
It's a contract, it's non-forfeitable, but then you get to the issue that the trial judge didn't get to, which is, can the state justify that? Is that, I'm just asking whether you agree with that general legal,
well, I can't disagree with that. I agree that there are circumstances under which contracts can be impaired, but that doesn't address that doesn't apply necessarily to every contract. There are certain contracts which legal principles would suggest should not be analyzed under that framework. These pensions are one of them. The Supreme Court has said again and again, most recently, I believe,
that's okay, you don't have to, just
you know,
tell
the
us.
Supreme Court has said that when rights are fixed at the time of retirement, they shouldn't be changed. So, and I'm talking about the case where the mayor had a disability pension. If rights are fixed at the time of retirement, then that is a class of contract where an impairment really should be, is effectively, I think, excluded from the more general analysis. Even in the earliest cases, there were estoppel cases, the Supreme Court talked about it, making adjustments to pensioners and payments, and said for these individuals, the race has already been run. So, if we accept the notion that there are contracts that can be impaired, I would suggest that there are contracts that can't be impaired. And the jurisprudence of this state, distinct from any other state, and that's why I don't think that out-of-state precedent has application, can be resolved by reference to those cases in which our courts have said the rights are fixed, there's been reliance, and in my view, there's nothing that my clients could have done to change their position in reliance on what the state has done, because they retired with an understanding of what they were going to get. So I would say yes, there are contracts that can be impaired. I would also suggest that there exists a class of contracts that can't be impaired, and that this is one that the pension with the COLA falls within that class.
Could you answer my question? Anything further?
Unless I think that if the court is assuming for purposes of argument the existence of the contract in the COLA within the non-forfeitable benefits program rights, then I would have nothing more to add other than to emphasize that the analysis can also be done under one of fundamental fairness, which seemed to be the way the Supreme Court was going in the last case. I think we get to the same place. If it doesn't have to be a remand, and the pensions are within that class of contracts, it can't and shouldn't be impaired.
Judge Carroll, do you have any questions at this time? There are going to be a few more attorneys arguing, but just wanted to ask.
I didn't have it at the time, thank you.
All right, very good.
Thank you.
Who's going to argue next? Mr. Auslander? All right.
Honors, may it please the Court, Charles Aspen, appearing on pro se. I understood your Honor's instructions that you wanted to make an argument that clarifies the issues, their essence. And I believe I can do that for you. I think there are three main areas the Court should focus on as it deliberates in this case. One is statutory interpretation of the non-fulfillable right. I understand from your questioning that at one point you assume there is a right. I won't assume that that is in fact correct. I'd like to prove it to you. But in essence, the state has spent a great deal of time in its brief arguing that the words of the statute don't mean what they say plainly and clearly. I believe that this case essentially starts and ends with the phrase benefits program. Surprisingly, in the state's brief, they indicate at one point that whatever the nature of the rights the statute grants, they want to make a point, as if the statute had not been interpreted by this court previously in NGA versus state. It was. And Judge Perillo found, writing to the court, that there was in fact a right to receive pension benefits. At that time, he indicated there was no right to have funding for those benefits.
That language is different.
No, I don't believe it was. I think it was a subsidiary holding, and because one of the arguments in that case, as I understood it, was that because you have this right to your pension, there's a concomitant right to fund it, otherwise it's meaningless. It's a right without remedy. But more importantly, Your Honors, even if it was dicta, I'm certain that Mr. Lughi would concede that during that case, the state conceded, as Judge Perillo noted in his opinion, that there were in fact enforceable contractual rights. The state's brief now is 180 degrees in the opposite direction. They're now saying that the phrase benefits program does not include COLAs, cost of living adjustments. And as I've tried to make clear to the court, not only do the rules of statutory construction indicate to this court that statutes regarding pension benefits are liberally construed in favor of pensioners, but it was a very expansive phrase they used. In fact, it's so expansive that the only exception listed in the statute is post-retirement health care benefits. And I argue to this court that persuasively that means when they use the phrase that the benefits program shall not be reduced, they meant all pension benefits, deferred retirement benefits, service retirement benefits, special retirement benefits, ordinary disability benefits, accidental disability benefits. None of those words or phrases appear in the statute, Your Honor. I can't imagine that Mr. Lughi would then argue that the phrase benefits program doesn't apply to all those various forms of pension benefits. Once this court makes a determination that the non-fulfillable right includes cost of living adjustments, and I suggest strongly it does, because we have other appellate court decisions indicating that COLAs are part and parcel of a pension, they just adjust the pension so it doesn't erode due to inflation. It is part and parcel of the base pension benefit. The state argues in its brief that it only applies to the base pension benefit. Those three words don't appear in the statute. The only description of the benefits covered by the non-forfeitable right are that the benefits program shall not be reduced.
Let me just interrupt you.
Yes,
The purpose of the statute, the 1997 statute, was to make sure that the state was complying with the Internal Revenue Code. That's in the legislative history. I didn't see a whole lot of anything in the briefs about the Internal Revenue Code. Don't we have to look at that to see what the 1997 statute was trying to get at in order to figure out what it meant?
I'm not sure that that edition in 1997 about the non-fulfillable right was strictly because of Internal Revenue Service regulations or federal tax law. Every time that the pension laws have been adjusted, including in that time, you are correct, but even in the 2010 law, and this 2011 law has been challenged, they've always had to update our state law so it's in compliance with federal statutory law regarding pensions, so it remains a qualified pension plan. My understanding, Your Honor, is that Governor Christie Whitman at the time and the legislature provided a non-forfeitable right that is a contractual right to pensioners to receive their benefits. They weren't obligated to. There are many states where that's not the case. It might be a property interest. Mr. Lughi had submitted a 2611D letter regarding New Mexico. They don't have contractual protections. for their pensioners. They have property rights. So they have some rights, but they don't rise to the level of contractual rights. In 1997, the state of New Jersey, for the first time in its history, and I use that language because that was from the state's brief at the time in the original NGA versus state case, provided a contractual right for pensioners to receive their benefits, and the benefits program wouldn't be reduced. I don't believe that right was placed there in compliance with federal law, although part of that original law did have adjustments to bring into compliance with the federal tax code. But that's also been the same with the 2010 amendments and the 2011 amendments that's the subject of this appeal. So I don't think it's required, but the state provided it. And in fact, in this new law, Your Honor, in 2011, one of the things they did, allegedly for benefits reform, was the non-forfeitable right has been repealed for new employees as of the effective date of the law, June 28, 2011. If it were, as Your Honor suggested, a federal requirement, the state could not have repealed the non-forfeitable right going forward. So I don't believe it was a connection, but there certainly were adjustments made to the law to bring it into compliance with federal tax law. The point I'd like to make, Your Honor, is that the statutory interpretation that should have been done by Judge Hurd was not, and that this court should be clearly convinced, based on the briefs you've seen from the appellants, including myself, that statutory interpretation, which this court does on a regular basis, what did the legislature mean when it wrote these words? You can safely believe, based on the statute, the words they used, and the rules of statutory construction this court abides by, that when they use the phrase non-fulfillable right means that the benefits program shall not be reduced, they meant all pension benefits, the sole exception in that universe being health care retirement benefits. That's critical. If Judge Hurd had actually looked at the statute and interpreted, came to the conclusion that cost of living adjustments are not part of the benefits program, that would have ended this case. There's no need to stampede for the Constitution and talk about the debt limitation and appropriation clauses. We don't have to talk about federal income tax law regulations. He could have just said, no, I read the phrase benefits program means base pension benefit. And that would have been the end of this case, strictly on statutory interpretation. I strongly urge this court that's not the case, because we have rules governing how one reads a statute. Remember, the non-forfeitable right was defined as the right to receive, or I should say that the benefits program shall not be reduced. Ordinarily, statutes don't define definitions. They could. They could have a definitional section and say the phrase benefits program shall mean, and then describe it even more particularly. They did not. So we're left with the rule of statutory construction that says to give words their ordinary and well-understood meanings, unless the legislature declares otherwise. We're back to what I initially started with. What does the phrase benefits, the plural, program mean?
I think we understand this already. Do you have another argument?
I do, Your Honors. Once one overcomes that initial statutory interpretation, that there was all part of the benefits program, there are two alternative legal theories that I urge the court to consider that would secure the payments of COLAs from the pension funds, not the state treasury, not the acquisition of debt. I strongly urge this court to see through what the state has argued. Essentially, it's an argument that's a straw man.
Your argument, not
Yes, Your Honor.
to preempt you, but as I understand it, your argument is they don't have to appropriate anything because the money is already in the trust fund. And
It
you're
is.
just asking that it be paid out.
To those people who retired before the law took effect. And the reason I state that, Your Honor, is that there are different classes of people. I'm here to represent my own interests, just as Mr. Grossman is here to represent the interests of his clients. But people who retired before this law took effect are in an entirely different position than those people who retired after or current or active employees in the system. The reason I note that is twofold. One, and jump ahead to my other independent legal basis, there are many equitable principles that support retirees who retired before the law took effect to receive their cost of living adjustments. The state's brief essentially says that equitable estoppel and other equitable principles don't ordinarily run against the state. That's not entirely true. The case that I believe Mr. Grossman was trying to recollect was the Chiarello case, in which that case, according to the appellate division here, and the panel indicated that ordinarily, when you retire, the laws and benefits in effect at the time that your retirement application is granted control. That was an individual who retired prior to other reform legislation taking effect. His retirement papers were held up by the Division of Pension and Benefits because they knew about the incoming law that had just been signed. He officially didn't retire or have the Board of Trustees act on his retirement application until after the law actually took effect, that is the effective date. Although about 4 months prior to the law being passed and signed into law by the governor, he had in fact applied for retirement. Because the delay was caused by the Division of Pension and Benefits and not the pensioner, that court held that fundamental fairness, another equitable principle, that people be given fair notice of a change in the law ahead of time so they could change their behavior or conduct accordingly, prevented the state from using the new law, even though technically his retirement papers weren't officially granted until after it took effect. So essentially they have stopped the state from enacting or using that law, I should say, against that pensioner. In addition, Your Honor, there's the principles of equitable estoppel, as I've just mentioned, and retroactivity. Retirees who've left before the law took effect, not retired after, have those independent legal bases to rely on besides the contract clauses, which I will address if Your Honor wishes me to. But one has to look at what Mr. Grossman had argued earlier. They're all equitable arguments. Prior to this law taking effect, it was introduced June 16, 2011, passed and signed by Governor Christie June 28, a span of almost 2 weeks. People who retired 5 months before the law took effect, a year, 5 years, 10 years, were on absolutely no notice that their COLAs would be interrupted, suspended, or for all practical purposes, terminated. They retired. They left the system. They quit their jobs. They may have found other jobs. They made plans in reliance upon them, Your Honor. There's nothing they can do to fix that. It is inherently unfair. That's what equitable principles are all about. It's simply not fair to change the rules, not only in the middle of the game, but as far as people who retired before the law took effect. They didn't just change the rules in the middle of the game. They changed the score after the game ended.
Okay, I think we understand it.
Very well, Your Honor. I'm going to address them in the contract clause arguments. At one point, hypothetically, you said if the court would have agreed that the benefits program includes COLAs, and that there is, in fact, an established contract, and that the impairment of it is substantial under both federal and state law. The question I believed Your Honor asked, or I understood it to be, was what about the impairment analysis? Does the state have a really, really good reason that it can break these contracts? And I submit to Your Honor is no, and you can make that decision on the record before this court. You don't have to send it back. I've outlined in my brief at length, but I do think it bears mentioning here. The state has a very long, troubled history in not making its annual required payments to the pension fund. Part of this record law was stipulated to by the state. Year after year after year, they failed to make their payments. And it got so bad, Your Honor, that ultimately they had to change the law, specifically the very law that Mr. Lugie will soon be defending before you. In the first case, NGEA versus state, the primary holding, as I understand it, is that there was no constitutional right to funding. That case.
We've heard arguments that I think we're starting to get a little.
Well, I was trying to explain, Your Honor, how that lack of funding doesn't, or should not cause this court to say, there's really an impairment analysis here. We don't have sufficient facts to make that determination. In that very same case, Your Honor, which was decided in 2010, almost a little over 3 years ago, both the state's witnesses, and I believe it may have been Mr. Nowak's clients, their expert witnesses testified that the pension funds were solvent for 30 years. And Judge Perillo and that panel of the appellate division relied on that. In fact, it cited it then. One of the reasons Judge Perillo said there was no impairment of the union's benefits was because it was solvent for 30 years. Now Mr. Lugie appears before this court and says that the pension system is on the brink of bankruptcy. It went from solvency 3 years ago for 30 years to the brink of insolvency. And I believe, Your Honor, that's simply not the case. But more importantly, Your Honor, when we talk about the pension funds, as Your Honor alluded to earlier regarding federal tax law, the monies that I and other retirees seek to pay for their COLAs comes from the pension funds. they're trust funds. Whatever monies are there have already been not only earned by the retirees, but the COLAs have already been funded. One of the things that you've seen, and I know that Mr. Leakey is certainly going to make a note of this to argue to you, is that somehow the fact that contributions by retirees doesn't go to funding their COLAs, that's not true. Every time an employee makes a contribution, the actuary computes two things: the base pension benefit and the amount needed for a COLA, based on all sorts of actuarial factors, lifespan, things of that nature. The point is, Your Honor, those people who retired before the law took effect contributed everything they needed to for their base pension benefit and their COLA benefit. The monies are in the Division of Pensions and Benefits. If they're not, and the state has misused them, that's misconduct and malfeasance on their part. They can't use trust funds for inappropriate, non-designated reasons, then turn around and ask this court, you know what, we don't have the money, let us impair the contract. What they're really saying is, we took the money and we want the victims of this act to make restitution. All of those monies were paid, Your Honor. I asked the court to pay close attention to how those numbers are in fact computed. Retirees who've left or retired have paid for both their base pension benefit and their COLA. The monies are there, they're subject to federal and state law, they're trust funds. I'm not asking this court to order the state to take money from the state treasury.
I think we
for COLAs.
understand you.
Very well. And lastly, Your Honor, although I've already touched upon the equitable arguments, I do want to emphasize to the court they are separate and independent than the contract clause arguments. You might determine maybe there's an impairment analysis and you send it back for a hearing on facts. You need not do that for retirees who retired before the law took effect. Equitable doctrines would permit this court to order the payment of COLAs, even if that other basis has to go down for a rehearing. And I can't urge that strongly enough, because this court has stated for the last 35 to 40 years that equitable principles prevent the state from taking away an individual's pensions, especially once they've retired and they've completed the contract. And as I indicated in my reply brief extensively, I've outlined that law, and it is an independent basis this court can rule upon, notwithstanding the argument regarding the federal and state contract clauses. Any other questions?
I don't. Judge Carroll, do you have any questions for Mr. Alston?
No, I do not, thank you.
All right, very
Thank
good. The interveners wish to argue next?
Just like to reserve a few minutes for rebuttal, Your Honor.
I have to tell you all in advance, I'm not sure that we look to require a rebuttal. And particularly, if everybody wants another round, I think it may, we may not need that. So we're going to see. We'll see if we need it. Go ahead.
Okay, and I apologize in advance, there will be some overlap, but I have an outline and I will be brief.
Focused is good.
This case is about benefits, Your Honor. It's not funding. Judge Hurd either misunderstood or ignored the distinction carefully outlined by this court in the NJEA case that's been mentioned earlier. There are tens of billions of dollars in pensions funds from which to pay COLAs. Whether the legislature appropriates in any particular year is a completely different question from whether promised benefits must be paid. So saith this court in NJEA. There have been years of zero state funding, a number of years of zero state funding, when basic benefits and COLAs have been paid. Benefit payment is not linked directly to appropriations. Appropriations have in fact been made over the last 3 years, although at the 1/7, 2/7, 3/7 rates outlined in the statute. The question in this case is not whether one legislature can bind another to fund pensions or basic benefits or COLAs. The question in this case is whether the non-forfeitable right, which creates a contractual right to receipt of pension benefits, includes COLAs. Judge Hurd's decision mixing funding and benefits is both troubling and broad. His analysis would apply with the same force to basic pension benefits as it does to COLAs. Under Judge Hurd's decision, the legislature could not have promised to pay even basic pension benefits. That directly contravenes NJEA, and this court should not adopt Judge Hurd's analysis lightly. It's a very broad analysis. I want to touch very briefly on sovereign immunity. I don't know if the state's going to argue it. It's certainly in the briefs. It was addressed in our briefs and is a bit of a red herring. as the state constitution's contracts clause protects all of the rights protected under the federal contracts clause. But to the extent that this court feels the need to address that argument, interveners reiterate that the state's position has been uniformly rejected and would effectively write the contracts clause out of the federal constitution, as it would make that clause unenforceable in either federal or state court. There would be no place to go. The COLA. The Judge Heard never got to the question of whether the non-forfeitable right includes COLAs. He opined that it did. But once this court applies the distinction between benefits and funding identified in NGA, the key question at this point in this litigation is one which Judge Heard thought that the plaintiffs had a strong argument, namely whether the non-forfeitable right includes COLAs. The Pension Adjustment Act of 1958 explained that COLAs are essential to a pension in order to lessen the diminution of the pension due to the eroding factor of inflation, which has caused significant hardships to retirees. The cost of pension adjustments, as has been said, are rolled into the pension system. COLAs are included in the calculation of the normal cost. There's no separate appropriation of monies for COLAs. All payments for COLAs come out of the retirement system, out of the funds. Plaintiffs in this case can be paid their COLAs for years to come without any additional appropriations. And there's nothing to suggest that there will not continue to be legislative appropriations to the pension systems, which before Chapter 78 required payments of both basic benefits and COLAs. In 1997, the legislature declared that vested members of the pension systems have the non-forfeitable right that we've been talking about. A non-forfeitable right to receive benefits is statutorily defined to mean the benefits program, as Mr. Oslander has said, that it cannot be reduced for any employee for whom the right has attached. What part of the benefits program is excluded? Retiree health benefits. All parties have cited to decisions of other jurisdictions with other constitutional or statutory language. Some find the COLA to be protected, some find the COLA not to be protected. The decision in New Jersey must be based on the language of the New Jersey legislature that enacted the non-forfeitable right to the benefits program, except for post-retirement medical benefits. In 1997, the legislature had already incorporated funding of COLAs into the pension system, had already arranged for payment of COLAs from the pension system, and had even described the COLA as part of retirement benefits in a sponsor statement. This court's NJA decision itself spent considerable time.
I don't mean to cut you off. I know you're careful with your peer, but we've heard argument on the same thing. And we really don't need to hear repetitive argument on the same issue.
I just want to make the point then that even within the NJEA decision, the court talked about non-forfeitable rights to benefits, and it did not make any distinction between pension benefits that are protected and pension benefits that are not protected. It didn't make any distinction between parts of the benefits program that are protected and not protected, and neither does the non-forfeitable right, except for retiree medical benefits. The legislature knows how to exclude something when it wants to. So, in conclusion, at this stage of the litigation, interveners ask this court to reverse the trial court's order, find that COLAs are covered by the non-forfeitable rights statute and impaired by Chapter 78. Should the court be unable to find that the impairment was not justified as reasonably necessary to serve an important public purpose, the question that you asked about before, this court should remand for fact-finding on prong 3 of the impairment of contracts test. That's notwithstanding the separate argument about estoppel.
Well, thank you very much. All right.
Your Honor, I guess last is least. I will take to heart your admonition not to repeat what has been said before. What I would like to address are issues which have not been discussed by my co-counsel, as well as to answer some of the questions that the court has had. I think on the original question that you had posed regarding a remand on whether or not there's been substantial impairment, our position in our brief has been that you can remand on that issue. I believe that the contract clause analysis is 3-step, and I think that Your Honor was discussing if you've addressed and resolved the first step, if there is a contract, what do you do next? Of course, the test is whether the impairment was substantial and whether the impairment was, in so many words, justified. And I believe that those matters can be remanded to the court because they arguably, well, certainly are fact-based. And this court did not reach any facts or made any fact findings at all. Now, Your Honor, I'm, again, going to try to avoid any repetition. But Your Honor also made a comment earlier about the IRS and whether or not the real impetus for 9.5 was to comply with the IRS. I'm not sure if there's a misunderstanding on the part of the court. There was IRS litigation and a settlement and legislation back in, I believe it was either 1992 or 1994, when the state took assets out of one of the pension funds, and the IRS came in and said, you cannot do that. And as a result of that, there was legislation basically required by the IRS. There was state legislation which essentially provided that the state will not do that. I'm sorry, Your Honor. And I think that that is the only substantive IRS statute or provision that I can recall. And believe me, I've been involved in litigation and pension system since 1994. And if there was any subsequent dealing with the IRS laws, it was generally to ensure that the benefits would not exceed the statutory amount allowed by the pension, by the IRS laws. That is normal and, in a sense, pro forma in many of the pension laws, that there simply be a guarantee that it not violate any IRS laws. But I can tell you from my involvement, from 1994, when the NJEA and CWA challenged the various machinations that were made by the legislature in the pension system, such as changing the interest rate or the assumed salary increases for teachers and other public employees at a certain rate, and then assuming the rate of return at a much higher rate in doing fresh starts where they would, normally the actuarial method looks back 5 years, so there's a smoothing, but the state had a tendency to choose a year that had a very high return, so the market was high, and they would go back and choose that. They did that in 2001, by the way, when they looked back to 1999, in the middle of a smoothing period, because 1999 was a very high market. So the suit was basically based on those types of activity. That suit, in essence, resulted in the 1997 legislation. And that suit ended up with two forms of the legislation, if you will. One was the Bond Act, and the other was the protections sought by the unions and by public employees. And the appellate division, this court, in the NJEA matter, which was also a case which we handled, pointed that out when it noted that in 1997 there were two bills that were presented to the legislature. One represented the theory that the way to protect benefits was to make sure that they were funded. The other, to protect benefits, was to provide a contractual right to protect the benefit and to leave it to the state how to fund it, whether to fund it, so long as the benefit was paid. Those were the two theories, and the court, in this court, recognizes them. The legislature made a decision. It chose to protect the benefit, and it left the funding to itself. So the decision in the NJEA case, the issue of the right, the benefit, the right to the benefit is not dicta. It is part and parcel of the legislative decision that the funding is not contractual, but that the benefit was. That was the decision that the legislature made in 1997. That was its choice, And the language in the NJEA case dealing with that distinction is not dicta. It goes to the essence of the 1997 law. Now, I'm not sure whether, I've learned over these many years that questions by the court and hypotheticals by the court do not mean that that is what the court is going to decide. And I know that you expressed the hypothetical that we're assuming it's a contract, if for no other reason than the Attorney General and the Office of Legislative Services have both opined in opinions that were submitted to the legislature that this is a contractual right. If you also look at the U.S. Supreme Court cases where they found that there was a contractual right in the U.S. trust case, they did it largely based on the word covenant. They did not require the word contract. And in, I believe it's another, I think it was a First Circuit case, a more recent one, I think it's Perillo, which we've cited. I think it's 173, Fed 3rd, 46. There, the court finds another important indicia of contract, that the statute provides for a prohibition or a protection against reduction of benefit. That was also indicative of a contractual right. Now, I'm not going to go through all of the other, the word non-forfeitable means a legally enforceable right.
I think we understand that.
Okay. I just wanted to make sure that the hypothetical was not merely a hypothetical.
We understand you. Anything further?
Well, I would like to address two other issues raised by the Attorney General in its brief that have not been addressed here this morning. One is the argument that they made that the law regarding contracts requires specificity, and that there's no specificity regarding the COLA. Now, this is not necessarily the contract. They seem to be acknowledging that the right to the benefits program is a contract, but they're using this specificity requirement to say that the COLA is not part of that contract. That's in their brief. But what's interesting are the cases that they cite. For example, I think it's General Motors versus Romaine. A fascinating case. The U.S. Supreme Court decided that, which is one of the specificity cases. In that case, what the state legislature did was say to employers that when you're paying workers' comp benefits, you can now deduct from that other sources of income that the employee is receiving, such as disability payments. And because of a court decision, the employers applied that retroactively. The legislature then said, no, you cannot do it retroactively, and the employers sued, saying that, wait a second, that is a contractual right because it was in the law. The court rejected that, not because there were collective bargaining agreements in effect, and that was the contractual issue. And the employers were arguing that the right to retroactively apply the other sources of income and deduct them was because it was a law, therefore it was deemed to be implicitly in the collective bargaining agreement. And the court said, no, not because the collective bargaining agreement itself spelled out these specific terms, but because the court said we're not going to implicitly impose into a contract or hold that it's part of the contract every single statute that the legislature enacts. It was not a specificity argument over what was in the contract. It was simply that we're not going to add legislation into each contract.
I think we understand.
And
Do
similar.
you have another point you want to launch?
Okay. Your Honor, on the issue of reduction, they're making the argument that there's no reduction here. Now, I would say that, Your Honor, we have all cited cases from around the country. And clearly the courts have gone different ways on this. generally or frequently based on particular words in the statute, such as the main decision that was recently submitted to the court was based on the fact that the COLA statute that the contractual right to the pension excluded the COLA. So therefore, the court said the COLA is not protected against reduction. But let's view the term reduction for purposes of our statute. They're saying that there's no reduction because we're not taking it back. But the essence of the COLA is to maintain the underlying retirement allowance in essentially current dollars. If that is the purpose, and that is certainly what the legislature said when they enacted it in 1958, if the purpose is to maintain the underlying pension in current dollars, then the elimination of the COLA means that the underlying benefit will be reduced. That is the
We
reduction.
understand the argument, yes.
Okay. Your Honor, I would also just like to note, again, I'm not going to go on to other areas, clearly the court is heard anything. I would just like to note that we recently found an Arizona case.
And you can provide us with that,
We've just found it. If not,
we just found it, I think, well, we're gonna ask for some additional briefing. Anyway, you can provide it. It's not fair to your adversary to sort of present it for the first time now.
I would only have cited it, Your Honor.
That's okay. All right, I think we understand your argument, we appreciate that.
May I just,
And you represent,
a number of the intervener plaintiffs involving probation officers, firefighters, and others, and David Fox at Fox and Fox. I just want to debrief, Your Honor. Two things about Judge Hurd's decision, which was May 25 of 2012. One, he made it clear that if COLA can be overturned, so can the base pension. So we're not just talking about COLA here. The implication of this is that anybody in the public sector receiving a pension, including a COLA and including a fixed amount, can have it changed. That's the theory. It's a far-reaching theory. Just want to make that point. And that's clear in the opinion, of course, is in the transcript.
I think we understand that point. Go ahead.
He also made it clear, and he said, he didn't get to this, but there are strong arguments on the COLA, an issue that he never got to. And I'll be within my 5 minutes, Your Honor. In terms of some of my plaintiffs, the ones we represent, we even had an issue involving the plain meaning of what something says. We lost. We wanted to go outside the plain meaning of something, and there was a decision that said you can't do that. And so we learned the hard way of appealing that, but if nobody says anything to the appellate division, I think the chances of prevailing against the plain language in that situation are not strong. And we actually have, the best arguments I don't have to make because the Attorney General and the Office of Legislative Services have already made them. And I hesitate to take your time up by quoting.
You don't have to because
You read them.
I read them again
All
last
right,
night.
I know, but I just want to make that point. I don't think it's been emphasized yet that our arguments are already corroborated by an Attorney General's argument, an OLS argument. And the only reason that we have that we should not follow those arguments, no matter how specific they are, is they don't specifically refer to the COLA. And the other argument is that the benefits doesn't statute, that you can't impair them, is that they don't specifically refer to the COLA. I mean, the arguments of the Attorney General as a result are a stretch. And I think it's because of the Attorney General now, not the Attorney General a few years ago. So all we're saying is the arguments are a stretch. They say
the COLA termination is only temporary. Well, it's 2 years and it takes committees and it could be 10 years, not that it matters. And there are other arguments that are simply just like that. Now, on the contract issue, I think, I don't want to beat it anymore, Your Honor. I just have one or two more comments. We know what U.S. Trust says about contracts. I don't think there's any question here, even Judge Hurd in May 25th of 12 seems to say this is, if you want to talk about contracts, you've got strong arguments. So we have, in addition, if you,
Yeah, I think we understand your argument.
one more point, just one more.
What I'm hearing is repetition here.
I
and we
don't,
really
I'm trying
want
not to do that. May I make one more point?
No, I think I'm going to ask you.
Okay, thank you.
And it's not because your arguments aren't good, but
Okay,
they've
thank
been thoroughly briefed. And we do really need to hear from the respondent as well.
Thank you, Your Honors. As a matter of statute, COLAs are not part of the non-computable right.
But they're certainly not post-retirement medical benefits, correct?
That is correct, Your Honor.
And that's the only exclusion in 43-3C 95A, right?
958, correct, Your Honor.
So
So
it's
then you
not-
go to 9.5B, Your Honor, and it says a non-computable right to receive benefits as provided under the laws governing the retirement systems or funds. The beginning of sub B lists each of those systems and funds. The TPAF, JRS, the closed systems, PERS, and each of those systems has their own law. So it's not just, is COLA a benefit? COLA is a form of a benefit, but it is not a benefit within the non-computable right statute. Each pension system establishes its own benefit structure based on years of service, salaries, so on and so forth. But COLA is separate and apart and on top of that benefit. So COLA is not a part of the non-computable right. Nothing that the Attorney General's Office or OLS said in 2006 is contrary to that. Nothing in Judge Perilla's decision is contrary to that. And that is the fullest reading of the limitations on what the legislature intended to create contractual rights.
Let me just, I'm not sure I understand your argument. Are you saying that because the COLA is a separate statute or a separate piece of the statute that applies more generally to these individual pension systems, that's why it's not included in the term?
Right, and it's just not part of the pension benefits. It's a separate additional add-on. And, and as the brief lays out, each pension system has its own laws that lay out what that benefit is, and COLA simply is not part of that, and there's nothing here. COLAs are not mentioned at all. There's no reference to the Pension Adjustment Act in this provision, and there's no basis to assume, to grant such a broad reading to the benefits and the laws of the pension system. So, for instance, JRS refers to the retirement system as the JRS. So the phrasing of the retirement systems and funds, that means something. And appellants want to just focus on A without putting that in the context of what is the protection afforded in sub B.
Can we stick to the language of A unless there's some problem with the interpretation of that language? Given the statutory construction, why should we look beyond the language of A? It seems pretty clear for purposes of this section. Non-forfeitable right to receive benefits means the benefits program. Any employee for whom that right has attached cannot be reduced. The provisions of this section shall not apply to post-retirement medical benefits which are provided pursuant to law. Where's the ambiguity in that language that would cause us to look closer?
Well, I think first you have to read A and B together. And second, the benefits program, when they're speaking of, they're talking about, each pension system has its own benefits program, and what they're saying is for the members of those systems, that's the scope of non-forfeitable right that's protected on, that's defined in 9.5A. You know, the COLA statute, the Pension Adjustment Act itself refers to, you know, it's a monthly retirement allowance or pension. You know, it's an adjustment to that. It's separate and apart from the benefits that are set forth under the laws governing those systems. So the COLAs are not a benefit under the laws governing the retirement system. They're an additional add-on apart each, you know, and the Pension Adjustment Act either establishes the system nor it's not. Right? So I think you have to read 9.5 A and B together, where A is the definitional section and B explains what that means and further defines its scope. So, and then I think a lot of the other, you know, so we went on this, COLAs are outside of the scope of the non-forfeitable right, and as a matter of statutory interpretation. And further, there is no, even, you know, there's no contractual right to that COLA benefit. And additionally, I think what Judge Berg was saying when he interpreted the non-forfeitable right in the context of the debt limitations clause, the appropriations clause, was much the same analysis this court went through in JDA 1, where it strived to interpret the statute consistent with the limitations upon the legislation imposed by the debt limitations clause.
But how does the debt limitations clause apply? Your adversaries say it doesn't apply because the money is already in the pension fund to pay these COLAs, at least today. Tomorrow, who knows, maybe, you know, maybe not the day after tomorrow, but they say the money's there. You don't have to appropriate anything in order to pay the COLAs today. So how does, in light of that argument, how does your debt limitation argument play out?
So sure, well, the debt limitations clause precludes one legislature from imposing a financial burden on future legislatures, right? And each legislature, each is a subject of appropriation. And what their theory of what that debt limitations clause is irrelevant would mean that and when they have no right to the corpus of the funds, that the legislature doesn't have authority, because eventually any money coming in any money coming out has to go in. And no one legislature can obligate a future legislature to put that money in. That's why the debt limitations clause is important, because each legislature, you know, through the Appropriations Act, reaffirms or impliedly suspends prior financial arrangements. That's the language application Berg. So that's why the debt limitations clause matters, is because it goes to the very issue of formation and what the legislature was authorized to agree to. It cannot agree by contract, by statutory contract, to obligate future appropriations by the legislatures. And to say that just because the money is in the pension fund for the benefit of retirees and members, and to which the members and retirees have no right to the management as a reported by itself, is to obligate the legislatures to fund that system. So that's where the debt limitations clause, the appropriations clause, it just informs the interpretation of the non-forfeitable right. And I think that's where Judge Berg was going with that. So the requirement of specificity is a fundamental part of the contractual analysis. Is that, and SPINA and the federal courts, whatever variation of the language they use, explains that legislatures make policy, not contracts, and the court should be most clear and cautious in interpreting a statute to apply a constitutional route. Part of that caution, part of that inquiry, is in the contours of the obligation. That comes right out of National Pacific Railroad. And this court in JDA 1 did go to analysis on the specific contours of what right was afforded. So the burden is on plaintiffs to demonstrate that any individual legislator, knowing and reading the non-forfeitable right statute, would have clearly understood that COLAs was within its scope. And they simply cannot do it. COLAs are nowhere mentioned. COLAs are nowhere referenced. The Pension Adjustment Act is not mentioned. And the burden is on the appellants to make that showing, and they have not done so. our court has explicitly rejected the contractual basis for employee retirement benefits. And our Constitution provides no constitutional protections in that way. And then you get into the three prongs analysis, but our position is that they have not even gotten to the first sub-inquiry, as the Robertson Court frames it, which is there a contract that's considered term?
Well, let's assume hypothetically that there is one. That we do find there's a contract. Would the remand be required to address that issue because the trial court didn't address it at all?
I think with respect, the brief lays out why there is no substantial impairment. So I agree with Mr. Novak, there's a three-prong analysis, the second one being a substantial impairment. Because there's been no reduction in the benefit, and nobody, Chapter 78 took not a dime from anybody, and you have no, as Will explained, you have no right to future holds that haven't vested, the court can conclude that the record before the court demonstrates there's no substantial impairment. If the court gets to the third prong, I think we drop in the footnote in our brief. We do acknowledge the remand on that third prong. That the court nobody's really talked about the sovereign immunity, but I think with respect to the federal claims, two lower courts have determined, based on 140 years of unbroken U.S. Supreme Court law, that states are immune from federal contract clause claims that seek to compel specific performance by the state.
I have a quick question.
Yes, ma'am.
Are there any other appeals that you know of dealing with this same issue? I mean,
With
no,
Chapter
I don't
78,
know
Your Honor?
right now, in this state.
With Chapter 78, Your Honor?
Yes.
I think, and looking at Ms. Whedon, I think between these two, I think there actually is one more appeal that lays out, I think it's Mr. Fox's case, that kind of lays out similar claims that are before this court on 2010 Chapter 2. It violates due process for certain changes. This is the most, these two are the ones most directly to the pension benefits.
Judge Carroll, do you have any questions?
I do not, thank you.
Okay, very good. We think we have heard sufficient argument to enable us to understand each side's position, and we are not going to hear another round of argument. However, we would like to give the parties the opportunity to specifically submit supplemental briefs directed to the question of the Internal Revenue Code and its significance or not with respect to how we are to interpret the 1997 statute. We will give the appellant's side 2 weeks to submit that brief. And at the same time, if you want to tell us about the Arizona case, that you can do that, even though it's not directly on point with the IRC. But if there's something new you want to tell us, we want something short. If the appellants can possibly agree on to join each other in one brief, we'd appreciate it. If you can't, that's fine. 15 pages, no problem. And then the state will have 2 weeks to respond. We won't take any replies. If we want to hear anything else after that, we'll tell you. But 2 weeks from today, whatever that date is, for the appellant's brief, supplemental brief, and 2 weeks thereafter for the state's brief. Thank you all very much.
Thank you.
I think your clients have all been well served here, and
Thank
it's
you.
a very interesting case.
Thank you.
I want to make sure we've done completely covered. So we're going to just take a minute here to let everyone